So the gun manufacturers are having kind of a bad week. Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist, I'm a lawyer and an academic, and I'm here to help you stand up for your democratic values against the MAGA crowd. Well, if you're like me, you've been extremely frustrated watching states like Texas pass the anti-abortion laws and watching the Supreme Court kind of stand on the sidelines. Of course, we know that the Supreme Court was all too happy to step in and stop President Biden from imposing some type of mandate on companies to either make sure their employees are vaccinated or somehow else protect the employees from the coronavirus. Apparently, they're concerned about the rights of people who don't want to wear masks and don't want to be vaccinated. But the people whose rights they are not concerned about at all, as it turns out, are young women who need to make a decision about getting an abortion. As you've probably heard, the Texas law has been challenged, including by the Department of Justice. And while the challengers are kind of winding their way through the courts, the Fifth Circuit Court of Appeals, which covers Texas and Louisiana, as well as the U.S. Supreme Court now twice, has refused to stop the law from going into effect. Now, in typical legalistic fashion, the basis for the Supreme Court refusing to stop the law from going into effect has nothing to do with abortion, according at least to their arguments. Instead, the Supreme Court says the issue is what's called standing. Standing is a concept that means to file a lawsuit, you need to have been harmed in some way. In other words, people who aren't involved in an issue can't just go ahead and file a lawsuit because they're upset about something. Courts in the United States will only decide issues based upon what are called actual cases and controversies. As I described to my students, they're not interested in theoretical discussions. They want to decide actual issues. So in support of that idea, standing is a requirement that the plaintiff in the lawsuit needs to be someone who actually was harmed by the action that they're taking to court. Now, one of the notable features of the Texas abortion law is it created a private cause of action, which means that independent citizens are able to file lawsuits against abortion providers. And if they win that lawsuit, they're able to get damages as well as legal fees covered. This is the scheme that's been criticized as deputizing citizens to take on abortion providers. And the irony then is when some private citizens actually did bring lawsuits based upon this abortion law, the Texas anti-abortion lobby was kind of surprised because of the fact that they thought simply having this law would just make people stop from providing abortions rather than actually challenging it in court. Now, this type of scheme that provides private individuals with a private cause of action is not all that uncommon, actually. I can think of a number of statutes right off the top of my head that have a private cause of action where independent individuals who are affected by a law are able to bring a cause of action against somebody who violated the law. For example, there's the Fair Debt Collection Practices Act, which was a law I dealt with a lot as a bankruptcy attorney, which says essentially if you're harassed in certain ways by a debt collector, you're able to essentially sue them for the harms that you've incurred. Another example of that would be, for example, the Lemon laws, where individual citizens are able to bring causes of action against automakers if it turns out that their vehicle does not meet a certain standard. And finally, I can think of the Clean Water Act, for example, which allows people to bring causes of action where pollution is hurting the community. That's the kind of litigation that was the subject of the movie A Civil Action with John Travolta. So these kinds of private causes of action are not unheard of in American law. But the really innovative aspect of the Texas law, though, is it makes it so that the only causes of action that can be brought under the legislation are by private individuals. In fact, the law explicitly says that somebody who's a governmental entity or some type of governmental official is not able to be either a plaintiff or defendant in such a lawsuit. Now, this is where the really outrageous issue comes up. Because the way that you typically challenge laws is you will file a lawsuit against, say, the Attorney General of the state or the governor of the state. Or in the case of a federal law, you'll file it against the United States, the President of the United States, the U.S. Attorney General. You need to have somebody who you're suing. You need to have an actual individual who is somebody responsible for the law who can be sued to bring this actual case and controversy before the courts. Well, because of the fact that this law is clear that the only people who can bring a cause of action are just individuals across the state of Texas, and that governmental entities and officials are actually prohibited from bringing such causes of action, well, then in theory, that means that people who are trying to stop this legislation from going into effect can't sue the government officials or the governmental entity, because those parties cannot be involved in the lawsuits. It would be like me being mad about something that Joe did and then suing David because he's easier to sue. Essentially, what the law has done is made it so that there's nobody for the plaintiffs in lawsuits trying to stop the law from going into effect to sue. And that's the argument that the Supreme Court has accepted. And that's why this law has been allowed to go into effect, despite the fact that, frankly, it's a clear violation of the plaintiff's constitutional rights, at least as they're currently interpreted by the Supreme Court. So here's where things get interesting, though. There's a piece of legislation that Congress passed in 2005 called the Protection of Lawful Commerce in Arms Act. And what that law did is it shielded manufacturers of guns and ammunition from any kind of legal liability as a result of somebody using a gun in a shooting. Essentially, as long as the gun was used as it was supposed to be used, which is to shoot somebody, then the gun manufacturer can't be sued about it. They can only be sued, for example, say if the gun exploded in the hand of the person who's doing the shooting. Well, unfortunately, that federal legislation, because it's federal legislation, and there's something in the Constitution called the Supremacy Clause, that federal legislation has stopped gun lawsuits both at the federal and the state level. So you might now be saying, well, I just heard that the parents of the victims of the Sandy Hook massacre just prevailed in their lawsuit against the gun manufacturer Remington. Well, those lawyers in Connecticut found a narrow exception to that law. And what it had to do with was not the liability of the manufacturers as a result of the use of the weapons, but the liability of the manufacturers for their marketing. That essentially through the games like Call of Duty, for example, that they'd been marketing their weapons to people who then used them in the shooting. The Connecticut Supreme Court found that that was an exception to the PLCAA. And that decision was appealed up to the U.S. Supreme Court, which then declined to hear the case, meaning that that would be the decision that would stand. So the problem we have then is we have federal legislation that basically stops states and stops individuals from suing the gun manufacturers for the harm that their weapons cause. So in steps California with a clever idea. Oh, if Texas is able to get around the constitutional protection of abortion rights with this novel scheme, well, we'll use the exact same scheme to allow individuals to sue gun makers. The theory is that because of the fact that it followed the same approach as the Texas abortion legislation, there would be nobody to sue to stop the law from going into effect. This legal scheme has been picked up by Illinois, who also introduced similar legislation. So you can imagine that right now the gun makers are kind of freaking out about it. After all, any legislation that can hold gun makers liable is something that the gun industry is very afraid of. And in fact, the NRA's former president, Wayne LaPierre, has called the PLCAA, quote, the most important gun legislation in the last 20 years. This legislation couldn't come at a worse time for the gun manufacturers because, as we know, the crime rate nationally has actually been going up a bit. It's not back to the levels that we saw in the 1990s, but it is still headed in the wrong direction. A new study that was just published in the Journal of the American Medical Association found that a major cause of the increase in violence are actually stand your ground laws. We may recall those are the laws that allow people to shoot somebody rather than backing away from them or trying to avoid some type of confrontation. Such laws became very popular among the NRA crowd in the trial of George Zimmerman for the shooting of Trayvon Martin in Florida. It turns out that some states, such as Alabama, Florida, Georgia, Louisiana, and Missouri, had jumps in firearm homicides after such laws passed as high as 33.5%. That's a huge jump that should make the gun manufacturers nervous if there are now going to be vigilantes out there willing to sue them to try to gain damages for the harm that they're causing under these new laws. Well, if you're interested in more information about the innovative approach that this Texas anti-abortion law took to try to take away women's rights, check out this video over here that I did before. I'll see you then. In the meantime, let's hope for continued progress. Thank you.